In the Immigration Law Clinic, my students have been wrestling with several topics where practice and theory converge. Specifically, our cases focus on two areas of law that exist independently, but collide in ways that have significant consequences, both positive and negative, for families and children. Immigration law and family law. We live in a time where families are mixed in terms of immigration status. That is to say, each member of the family could have a different immigration status or none at all. This is a result of federal immigration laws that are in desperate need of reform. The federal immigration code has been compared to the tax code, both in terms of complexity and incoherence. And just like in tax reform, politics plays an important role in advancing or inhibiting important reforms in immigration laws, and that's no less true today. Meanwhile, our family laws remain largely developed on a state-by-state basis, and family courts are state courts. Rulings can differ from county to county and judge to judge. Because immigration involves the right of someone to be physically present in the country, and because so many families have mixed immigration status, many interesting legal questions are unfolding in these areas as we speak. I'll use the example of the cases we work on in the clinic, special immigrant juveniles. These cases arise from well-documented humanitarian crises in Central America in which children are fleeing gang violence, abuse, neglect, abandonment, endemic poverty, and governments who are unwilling or unable to protect them. There is a specific provision of immigration law that can apply to these cases to put these children in a safe home and on a path to citizenship here in the United States. Our job in the clinic is to secure that path. But here's where family law and immigration law collide. The federal immigration law specifically asks the state family courts to make factual findings and a determination that it is not in the child's best interest to be returned to their home country. That standard, best interest of the child, is the guiding principle for family courts. Not so in immigration. So this sounds like a reasonable delegation of authority. Well, in order to seek these special findings, we must comply with laws largely set up to deal with families whose members all live within the United States. And that is not the case for these children. Family court judges, many of whom are new to these types of cases and not immigration scholars, grapple with differing standards for the treatment of children in the United States versus Central America, and struggle to comprehend the structure of the federal immigration code, with which they're not as familiar. Requirements like fingerprinting of the child's caregivers or relatives who are standing in for the parents become problematic when those individuals may be undocumented themselves and lack the proper documentation to be fingerprinted. Issues like service of process and notice to the abusive parent that the child has escaped from become infinitely more complicated when that parent lives in a rural village in Guatemala. Our family court system is just not designed to contemplate the needs of immigrant families. To make matters worse, there's no system designed to facilitate communication between the family law system and the immigration law system. So, for example, a parent who is detained by immigration authorities may be stripped of their custody rights in family court if they don't appear to assert them. But no one in the immigration system communicates to the family court system to explain that the parent can't appear because they're in detention. Families are thus separated under laws designed to keep families together. In other cases, an abusive parent with immigration status could be granted custody of their United States citizen child, while the loving, protecting parent is deported for lack of status. Practitioners, scholars, and activists are working very diligently to bring these two areas of the law in greater harmony. And in the meantime, a host of questions emerge as to what the proper role of each is for immigrant children and families. Thank you.